How common is family violence in Texas? According to the Texas Department of Public Safety, in 2015, an estimated 194,000 reported family violence incidents were reported. The Texas Council on Family Violence estimates that 1 in 3 Texans have been victims of domestic violence in their lifetime. It is worth noting that many incidents go unreported, so the actual prevalence of the issue could be much higher. Hi, my name is Peter Sayadzad, and I am one of the attorneys here at the law office of Bryan Fagan. Today's video is a complete guide to family violence in Texas, including the main types, limitations, and criminal procedures. According to the Penal Code, family violence refers to any act of violence or abuse committed by one family member or household against another member of the family or household. The perpetrator intends to cause bodily injury or sexual abuse, while the victim has no means to protect oneself. There are 3 main types of family violence recognized in Texas. The first type is domestic violence, which can occur between current or former spouses, individuals who share children, or individuals in a dating relationship. Domestic violence includes physical harm, emotional abuse, sexual assault, threats, or coercion. The penalty for this type of charge is a Class A misdemeanor, which would consist of a fine up to $4,000 or up to 1 year in jail, and sometimes might consist of both. Another type is continuous violence against the family. Under Texas law, continuous violence is defined as 2 or more acts of domestic violence committed against a family or household member within 12 months. Continuous violence is a 3rd-degree felony in Texas, and the penalty is 2 to 10 years in prison with a fine up to 10 grand. The third type is aggravated domestic violence. It is an act of domestic violence involving serious bodily injury or using a deadly weapon. It can also include threatening a member of the family while being armed. Aggravated domestic violence classifies as a 2nd-degree felony with up to 2 to 20 years in prison and a $10,000 fine. So what should you do if you are accused of family violence? The most common defense stance is self-defense. You need to prove you are protecting yourself or another from imminent bodily injury. In some cases, the alleged victim may have made false allegations of family violence for personal or strategic reasons. If you can show this, you might be able to have the charges dismissed. Different types of family violence have different penalties, as discussed before. However, the state of Texas has ways to protect victims from future assaults. One such way is a protective order. Protective orders have penalties if violated, such as up to 1 year in jail or probation for up to 2 years. Individuals accused of aggravated domestic violence can lose their firearm possession rights for up to 5 years. Family violence is pervasive in Texas, with far-reaching consequences for individuals and society. Recognizing the different types of violence and understanding the limitations of reporting is critical. However, an experienced criminal defense attorney is required to go through the criminal procedure. Our criminal law attorneys provide complimentary consultations and can help you navigate the court system. Please call our office today at 281-810-9760 to schedule your consultation. And don't forget to subscribe to our YouTube channel to learn more about Texas criminal law.